Good morning. First of all, I'm sorry I had 4 years of French in school, but it never really made it to be able to hold a presentation. I was asked to talk about the case at the Court of Justice, the PRISM Safe Harbor case, and give you some insights into that. There are basically three parts. The first is really the case that we had at the Court of Justice. The facts that we looked at was really the, okay, just gotta go. This is not in sync with there, but now we're there. How the whole thing started off was really the disclosures by Snowden, where we kind of roughly knew that there is a system called PRISM, that certain companies are involved in it. And it was the first time that this was not just a conspiracy about mass surveillance and so on, but really knowing that there is something going on and where we had documents to bring stuff forward. And the underlying idea was really to connect privacy rights of Europeans with the commercial interest of the US, basically saying, if you want to be on a European market, you also have to give us at least somewhat decent privacy protections. So we started off with the Snowden slides. There were the following legal arguments in the case. Basically, if I'm a little Austrian smiley down here, I have a contract with Facebook Ireland for tax avoidance reasons, and not with Facebook US. However, Facebook Ireland does forward all the data to Facebook US, where it then ends up in the PRISM system. And the interesting thing is you can only, under European law, you can only send data from the European Union to another country if there is what they call adequate protection. So there was a long debate about what adequate protection could possibly mean, but I walked up to the court and said adequate protection is probably not mass surveillance, and that was the legal argument. So it was rather simple, and the background why this whole case could be brought the way it is because these companies are split into European and US companies, so we actually have jurisdiction over them a lot. The strategic approach was basically that we have what I call kind of public-private surveillance, so the NSA and these, what they call electronic communication service providers, cooperate under the law. The interesting thing is that Facebook, in this case, we based that on Facebook, but we could have done it with any other company, is subject to US and European Union law. So we have both jurisdictions applied to these companies, and that's basically the problem that they have as well. The other thing that was interesting is that the European Union law regulates these third country transfers, so that is what we used as well. And that the European Union law has to be interpreted in the light of the Charter of Fundamental Rights and the European Convention of Human Rights. So we do have all these fundamental rights engaged whenever a private company sends data abroad, and this was kind of the overall setting where the case was brought. One thing that's kind of what we did is we looked at the data retention judgment by the Court of Justice. So the Court of Justice said that data retention is illegal under the European Union law, and we compared that to PRISM. And basically in all the categories you have, PRISM was worse than data retention. So it's content data versus metadata. PRISM makes data available, data retention mainly just stores it. The one is more or less endless, the other one is 24 months. So in all these categories, we basically walked up and said what's not allowed in the European Union cannot be allowed if we send data to another country. What was interesting as well is we have a different understanding of what an interference even is. So in the US, there's a lot of debate about data really being pulled and used. The European Union law is much broader, so only the fact that data is made accessible already triggers my European Union rights. So oftentimes I'm asked if I could ever prove that the NSA was really looking into my data, and the standard answer to that is you don't even have to prove that anybody's looking into your data. Under European Union law, just the fact that they have to make the data available would trigger your rights. So I don't just have to prove that, for example, Facebook has to make my data available. I don't have to prove that data was actually used by the NSA to have a case. So the scope of protection in Europe is really very broad. How did the procedure work out? Just a practical thing. What was really interesting, we filed the whole thing with the Irish Data Protection Commissioner. That's that guy in front of his office. And what was interesting is typically with these surveillance cases, there's a big debate about the facts. In our case, I'm sorry, this is cut off down here. The Data Protection Commissioner of Ireland went onto national radio and said that he doesn't think it will come of much of a surprise that in fact the US intelligence services do have access from US companies. The companies are cut off here. So what's interesting is that there wasn't any debate if this is actually happening. We're really only debating the law in this case. Right now, all these companies come up and say, we don't really do this, this is much more limited, but the case was really on the facts that more or less Snowden disclosed. What happened then at the Court of Justice? We went through the Irish system and were then referred to the Court of Justice. And there were a couple of findings by the European Court of Justice, and on the Charter of Fundamental Rights, they first found that Safe Harbor, which was the data transfer system to transfer data to the US, is invalid. And that was overnight, so in the moment you use this system, you would have had to shut down your whole outsourcing operation, whatever you do under Safe Harbor. And that was interesting because even we argued that there should be an implementation period or something like that, but the Court of Justice shut it down in the very moment. First of all, they said that mass surveillance, as they call it, violates the essence of the fundamental right to privacy. I'm going to come to the essence right away. And the fact that there is no legal redress in the US violates the essence of your right to Article 47, which is the right to a fair trial, more or less. If I talk about the essence, that's a real legal term, but generally when we have an interference with a fundamental right, we talk about proportionality, and there is a system how to look at what's proportionate or not. So typically we talk about if an interference by the government is proportionate to the aim it pursues or not. In the case of Safe Harbor, the Court of Justice actually says it's a violation of the essence, so it's outside of the scope of proportionality. So basically they said this form of surveillance is so heavy and so insane that there is no way to ever justify it. And that was actually the first time the Court of Justice ever found a violation of the essence of any fundamental right. So that was really a very bold and broad statement. Other key findings was that there has to be what they call essentially equivalent protection in a third country. So it has to be basically the same level of protection in a third country than the European Union to be able to send personal data to a third country at all. There have to be effective detection and supervision mechanisms, so there has to be oversight over the privacy landscape in that country. And there has to be legal redress in line with Article 47, so I have to be able to go to court and complain about mass surveillance cases. The interesting thing is that is a much higher standard than a lot of European member states actually provide for right now. I'm Austrian, so if I complain about the German surveillance systems, there is no court to go to in Germany. And I think this whole judgment has to be seen as a judgment on national surveillance, or like on national security and surveillance in general, not just about really the US in any case, but obviously it's mainly debated about the US now. Second part that I wanted to talk about is, and that may be relevant for the practice now, is what are the alternatives? Safe Harbor is dead, so what can I do if I want to send data to the US or to other countries in general? First of all, I think there are a lot of technical solutions that may help in certain cases. First of all, if I can limit EU-US data transfers, if I just have the option to keep data in the European Union with a European provider, then I basically avoid the whole debate at all. There's also the possibility to, for example, encrypt data and then send it to the US if that is suitable for the system that you have. Another example that may work is what Microsoft Cloud does now with Deutsche Telekom, where they basically have the whole data hosted and only accessible in Germany. So there's no access from the US anymore, and that's basically a technical solution so that there is no access from a US side, and you basically zoom out of the whole legal debate there. A lot of US companies have now argued that there is consent. That's kind of the standard answer to any kind of privacy problem in the US. The problem is, under European Union law, consent to have your data sent, for example, to the US has to be freely given, informed, unambiguous, and specific. So I think the first one is Facebook right now. They now have a wording saying your data may be processed outside of the European Economic Area, including the US, which obviously doesn't inform you that the data is actually subject to NSA surveillance. And you can also just say, okay. So if you really want to have consent under European understanding of it, you would have to have some wording like, I agree that all my personal data is made available to the NSA, and then have a yes or no possibility, which typically none of these companies is going to provide you for, especially because under US law, there are gag orders, you're not allowed to actually tell about any of this. So bottom line, consent is not going to work out if you want to have a stable solution. There are a bunch of other exceptions that are really relevant. If you really need to send data to the US, so we're not talking about outsourcing, but let's say you're an airline and you really need to send the traffic data to the US, Then there is stuff like performance of contract that allows you to send data to other countries in general. But all of these exceptions typically don't help you if you have more of an outsourcing situation than something where you really have to send data to another country. What most companies move towards now is what they call standard contractual clauses. So you can have a contract by a European company with a US company saying that the US company follows European law on a contractual basis. So it's not under the law, but you have a contract saying I follow European law. The problem is that there is a clause in these contracts saying that the US entity has to inform you about any kind of law that applies to them. And if you're informed about that, you have an option to cancel the contract with the US supplier. And that is exactly the problem, that typically they would have to inform you that if there is such a surveillance law, and then you would have to cancel these contracts. If you don't do that, there is an Article 4.1 in the decision. The different decisions, the articles are a little bit different in each one of them, but it's basically saying the same, that the National Data Protection Authority, so for example in France, the CNIL, could suspend the data flows even though you have standard contractual clauses in place if there is such contradicting law in the other country. The rationale behind that is really like if you have a supplier in North Korea, you can have a wonderful contract, but if North Korean law says it's all void, then the contract doesn't help you. So the big problem, I think, in these cases is really if you look at companies that are covered by the surveillance laws in the US. We have to differentiate there. There are certain companies you want to exchange data with. Let's say you're a hotel, you're an airline, you're some international group that exchanges data. Then you typically wouldn't fall, for example, under the FIC Act, because that only applies, at least the relevant part, or the one that people are outraged about the most, only applies to electronic communication service providers. So it would apply to your Google, but it wouldn't probably apply to a sub-company that you have in the US. So in these cases, you can probably still get around with standard contractual clauses. However, if you really have the cloud services and so on, standard contractual clauses are not really something that would uphold 100% either. Now, the third part I wanted to talk about is Privacy Shield, which is the new proposal by the European Union about how we can transfer data to the US. What happened is that after Safe Harbor was killed, there was a lot of pressure from the industry and from the US government to come up with a new Safe Harbor plus Safe Harbor 2. And as far as I understood, people walked up the last day of the negotiation and said there is no deal. At least that's what I was told. I'm not 100% sure if that's correct. But interestingly, the day after that, the Justice Commission of the European Union came up in the European Parliament and said that there is a deal with the US. And 2 days later, they finally put up this logo and this name called it Privacy Shield, but there wasn't any text of it, so no one knew what this deal is actually about. And interestingly, a US NGO asked the US government for a copy of the text a couple of days later, and a couple of weeks later they got this answer back saying that they cannot get a copy of Privacy Shield because the record that you request does not exist. So they basically said there's a treaty, but it's not existent yet. And that was kind of the start of Privacy Shield. About a month later, we actually got a text. I think Privacy Shield is not going to hold up in the long run. It's now there. It's legal for now until a court overturns it. So you can use it now, but I don't think it's going to be holding up all too long. There are basically two hurdles after the Court of Justice ruling. First of all, you have to be essentially equivalent, which is equivalent to European data protection rules. And then you also have to fulfill the requirements of the Charter of Fundamental Rights. So it's really two sets of rules that apply to you for a data transfer. And I think the first one is actually relevant for the commercial data usage. The second one is relevant for mass surveillance more. If you look at the private sector, which is the first part of Privacy Shield, about what companies are allowed to do with data, they basically follow what they call a notice and choice system. And there are a lot of issues about it, but I'm just picking out one thing. So the Court of Justice said there has to be essentially equivalent protection in the US. But if you look, for example, at what Privacy Shield applies to, this is what all the things that European data protection law covers. So it's from collecting the data all the way to destruction of the data. So anything you can possibly do with data is covered by European Union law. However, Privacy Shield only gives you an opt-out so that you can say no if data is disclosed by transmission or if there's a change of purpose. So just this very simple graphic shows you how Privacy Shield, this new system, is just much smaller and much more limited in scope and can hardly be what they call essentially equivalent. To put that in another graphic, if you collect data, use data, store data, you don't even have an opt-out under Privacy Shield, while you would have to have, for example, consent in the European Union. Only if you then don't do that, but also disclose data or change the purpose of the data usage, then only you have to provide for an opt-out. So it's the whole scope in the private sector is much more limited, which leads to kind of an unfair situation as well, because US companies can do much more with data and still be on the European market than European competitors. What was kind of interesting as well is the redress. So if you're that little guy up there and you want to go after Facebook, you first have to go to Facebook and complain about them. After 45 days, you can then go to Trustee, which is the private arbitrator that Facebook chooses and pays, where you can have your case heard. They can then make a decision over whatever Facebook does with your data. However, that decision is not enforceable. The only consequence is that they may be kicked out of the program, but it's not enforceable in the sense of if you want to have access to your data, that they can actually force Facebook to give you access to the data. You can then complain with your National Data Protection Authority if that doesn't work out, and they can raise the issue with the Department of Commerce. They can also raise it with the Federal Trade Commission. And they can both go after Facebook, but none of these are things where it's guaranteed there is actually going to be enforcement. So it's stuff where they say they will try to do something, but they're not going to guarantee it. So you don't really have a right that this is really enforced. You just have an option that this may be raised in a kind of friendly manner. If you don't get your European Data Protection Authority to do its job, like the Irish DPC that I deal with the most, you first have to go to a European court to even force the Data Protection Authority to do its job. However, if you're done with all of this, there is a new system in place, and that is called the Privacy Shield panel. So it's a panel of lawyers that have to be accredited in the US, so it's going to be mainly US lawyers, I would guess. And you can then raise issues with this Privacy Shield panel, basically through a video conference with a US panel of privacy experts. After you've gone through all of the other things, you can only go to the Privacy Shield panel if you've done all the other stuff. The fun thing is that even that is not enforceable, so it's basically a recommendation, and this can then be turned into enforceable law if you first go to a US judge. So that is basically the enforcement system of Privacy Shield. You can see how you have to go through all of these things to finally get to a US judge if you want to have something that's really enforceable. That is taken into consideration that a company really doesn't want to do it. Like, they may just do stuff beforehand because they fear all this trouble too. But if you really don't want to do it, that's all the stuff you have to go through. There is this fair competition question that I already raised. If you're a European company, you have to follow all the fancy European privacy rules. If you're a US company, you only have to follow this kind of Privacy Shield thing. So there's a certain question why we even allow that in the European Union. The second part that's interesting in Privacy Shield is actually the mass surveillance debate, or the NSA debate. And what was interesting is that the European Commission came out and said that US authorities assured that there is no indiscriminate or mass surveillance by national security authorities. And that's basically, that assumption is the basis for a Privacy Shield. Now, there's a lot of debate what indiscriminate and mass surveillance actually means. So depending on what you think it means, they may be right or wrong. However, if you look into the Privacy Shield, actually, there is an Annex 6 in the page 4 of it, where they themselves say that data is still used in bulk, or there's still bulk collection for 6 different purposes, including stuff like transnational criminal threats, which is a very broad statement. Just a threat of a transnational crime is already enough to do bulk collection in that sense. That may be more relevant for 12.333, but basically that's the basis that the European Union has now argued its Privacy Shield on. So if they say that there's still mass surveillance or bulk collection, if you at least call it that way, that is kind of interesting that they say at the same time there isn't anything like that, if their own decision says there is exactly that. If you look at the actually underlying Presidential Policy Directive 28, and there's a page 3 and there's a footnote on bulk. And I thought that was kind of interesting as well, that we don't even exactly know what bulk collection means. Because there it says, for example, that if they temporarily acquire data to then target someone later, this wouldn't be considered bulk collection. So if you collect all the data and later target someone in the data, then this is not bulk collection but targeted, even though you bulk collected everything beforehand, which is from the definition just miles away from the European Union fundamental rights doctrine, where already kind of collecting the data is a violation of your fundamental rights. So all of this is kind of really unstable, I think, if it gets to the European Court of Justice. Finally, and I think that's kind of the last thing to talk about, Privacy Shield. There's also new forms of redress because there isn't any place you can actually go to as a European. So if I'm that European guy trying to complain about US surveillance, I can go to my National Data Protection Authority, so in France that would be the CNIL. And the interesting thing is that I first have to prove that the data, I have some problem. In my case, I actually brought a case. I was put on a security list for a flight to the US, and I said, I don't know why I was put on this list. I would like to complain to the Privacy Shield Ombudsperson to help me here. However, my Austrian DPA said that I first have to prove that the data that was used to put me on that list was actually sent to the US under the Privacy Shield Standard Contractual Clauses or Article 26. So I first have to prove which data the US used to make a determination to actually be able to even raise the issue with my National Data Protection Authority. Typically, you're unable to do that. You just know that you were denied a visa, you were denied boarding, you have some issue, but you never know on which basis that happened. So already on this very initial step, you're going to fail to even get to the Privacy Shield Ombudsperson. If you can prove that and the DPA forwards it for some reason, then you end up at the Department of State. There's a Privacy Shield Ombudsperson that will internally clarify stuff within the US services, but you're not allowed to know anything about it. And you will get an answer. And the funny thing about Privacy Shield is the answer is already in the Privacy Shield. We already know what the answer is going to be in each case. And the answer is going to be very simple. First of all, they will neither confirm nor deny that there was any kind of surveillance or any targeting anyways. Secondly, they will say that the case was investigated. And third, they will say that the US either complied with all the rules or the non-compliance was remedied. It doesn't say that you're even informed about if there was a compliance or not. So you just basically get this standard rubber stamp answer. And that is what the European Commission will then have to defend in front of the Court of Justice as redress or a fair trial if you are raising an issue like that. So I think Privacy Shield, bottom line, will go back to the Court of Justice sooner or later. I hope someone else will do it, not me. But there are already two challenges at the lower court, which have huge standing issues, but there are challenges coming up on Privacy Shield as well. So this was actually my last slide, but the overall problem that we have right now is that we really have a huge conflict between European fundamental rights and mass surveillance laws in other countries, and I don't really know how we solve this issue right now. I can just flag it and explain to you what the problems are in a kind of quick summary. I hope that was helpful for you.